The marble halls of the United States Supreme Court grew eerily quiet as Chief Justice John Roberts leaned forward, his usually composed demeanor giving way to clear frustration. His intense gaze was locked on Elon Musk, who stood confidently at the petitioner's lectern, dressed in an unusually formal Navy suit. "Mr. Musk," Chief Justice Roberts began, his voice cutting through the room with an unusual sharpness. "This court is not a platform for your social media theatrics. We are here to address constitutional law, not technological innovation, and certainly not the kind of spectacle you seem to think can replace sound legal reasoning." A collective breath was drawn from the audience, as the Chief Justice's words hung heavily in the air. Never before had the court seen such pointed criticism aimed at an appellant. Even several associate justices shifted uncomfortably in their seats. Musk, the world's wealthiest entrepreneur, remained calm under the intense scrutiny. He adjusted his papers without haste, a faint, almost imperceptible smile tugging at the corners of his mouth. "Thank you for the clarification, Mr. Chief Justice," Musk replied, his tone measured and respectful. "If I may, with the court's permission, I'd like to present evidence that I believe could fundamentally shift our understanding of the First Amendment in the context of the digital era." Roberts' expression tightened, his patience clearly wearing thin. "Mr. Musk, I've reviewed your brief. What you propose is not only unprecedented, it's frankly preposterous. Your company is not above the law simply because you think technological progress demands it. What unfolded next would leave the highest court in the land stunned, forever alter the course of digital speech law, and redefine the relationship between America's most influential judge and its most polarizing business figure. But before we dive into this remarkable courtroom showdown, don't forget to like and subscribe for more gripping tales of high-stakes legal battles that have shaped American history." At 69, Chief Justice John Roberts had overseen the Supreme Court for nearly 2 decades. Appointed by President George W. Bush in 2005, he had earned a reputation as a cautious institutionalist, valuing precedent, moderation, and the court's credibility over ideological purity. Renowned for his sharp legal mind and meticulous attention to detail, Roberts had guided the court through increasingly polarized times, striving to uphold its image as an impartial arbiter of constitutional issues. However, in recent years, Roberts had voiced growing concerns about the overwhelming influence of tech companies on public discourse. In several opinions and speeches, he questioned whether the traditional First Amendment framework could adequately address the unprecedented power wielded by digital platforms. The founders never imagined private companies having more influence over communication than the government itself, he had remarked at a judicial conference only months before this landmark case. On the other side of the bench stood Elon Musk, 53, the controversial tech mogul whose acquisition of several major social media platforms had propelled him from business leader to a central figure in the debates surrounding free speech, content moderation, and the future of public communication. In response to mounting regulatory challenges to his platform's content policies, Musk had taken the unprecedented step of personally presenting his case before the Supreme Court, one that would determine whether his companies could claim First Amendment protections against certain government regulations. The legal world had been taken aback by Musk's decision to represent himself, choosing not to rely on the top-tier Supreme Court lawyers typically entrusted with such high-stakes cases. Legal analysts were quick to dismiss it as yet another publicity stunt from a man known for making unorthodox choices. "This isn't about publicity," Musk had insisted to reporters outside the courthouse that morning. "This is about defending the core principles of free expression in the digital age. Some battles are too important to hand off to others." Now, standing before the 9 justices, the stakes were higher than ever. The case, Platform Innovation Corporation v. Federal Communications Commission, would determine whether new regulations requiring specific content moderation practices infringed on the First Amendment rights of digital platforms. But beyond these immediate questions of regulation, the ruling could fundamentally shift the balance of power between the government and the rapidly growing tech industry. In the front row of the gallery sat key figures from both sides of the debate. Executives from tech companies watched with apprehension, knowing the outcome would set a precedent for their own operations. Meanwhile, government officials, regulators, and legislators observed closely, hoping the court would affirm their ability to regulate the ever-expanding influence of digital communication platforms. The tension in the chamber had been palpable even before the Chief Justice's rare, pointed rebuke. For Roberts, the cautious institutionalist, Musk represented more than just a litigant. He embodied the disruptive, unpredictable forces reshaping the modern information landscape. Musk, the maverick known for challenging the status quo, stood before a court deeply rooted in tradition and precedent. The clash between the two was inevitable. As the heated exchange continued, Associate Justice Elena Kagan leaned toward Justice Brett Kavanaugh and murmured something to him. Kavanaugh gave a slight nod, his face betraying a hint of concern about where the argument was heading. Chief Justice Roberts cleared his throat, his patience thinning. "Mr. Musk," he said firmly, "this court granted certiorari to address specific constitutional questions, not to entertain technological hypotheticals. Please limit your arguments to the legal issues outlined in your brief." Musk nodded politely in response. "Mr. Chief Justice, I intend to focus on those exact questions, but I believe the court must first understand the technological context that renders traditional legal frameworks insufficient." Roberts' jaw tightened, his voice sharpening. "We are more than capable of understanding technological context, Mr. Musk. What we require is solid legal reasoning, not a lecture on innovation from someone with no formal legal training." The Chief Justice's unusually dismissive tone sent a ripple through the courtroom. A reporter from the Washington Post furiously typed on her phone, capturing the tense moment. What had begun as a confrontational exchange now seemed to escalate into open hostility, with the nation's top judge seemingly intent on putting the tech billionaire in his place. What neither man could have anticipated was that the next 30 minutes would not only alter the trajectory of this case but potentially reshape First Amendment jurisprudence in the digital era. "Mr. Chief Justice, with all due respect," Musk began, his voice steady but resolute, "my lack of formal legal training might actually serve as an advantage in this case. I'm approaching these constitutional questions without the constraints of conventional legal thinking, constraints that were developed in an era before digital speech platforms even existed." Justice Samuel Alito leaned in. "Mr. Musk, are you suggesting that established First Amendment jurisprudence is obsolete?" "Not obsolete, Justice Alito," Musk replied quickly, turning a page in his notes. "Incomplete. The court's existing frameworks assume communication channels with physical or practical limitations. Digital platforms operate without those limitations, which raises entirely new constitutional questions." Before Musk could continue, Justice Sonia Sotomayor interjected. "But Mr. Musk, your company's made deliberate choices regarding your algorithmic designs. The government isn't regulating your speech, Mr. Musk. It's regulating how your business practices impact public discourse," Justice Sotomayor remarked. Musk acknowledged the question with a nod. "Justice Sotomayor, that distinction is exactly what I aim to address. Our algorithmic decisions are not just technical choices, they are expressive conduct. When the government mandates changes to those algorithms, it's compelling speech in a way the founders never envisioned, but would certainly recognize as constitutionally troubling." Chief Justice Roberts shook his head in visible frustration. "Mr. Musk, the court has heard variations of this argument before. What you're presenting as groundbreaking is merely a technological application of long-established principles. Unless you have something truly new to add." "I do, Mr. Chief Justice," Musk interjected, causing several justices to exchange raised eyebrows at the breach of protocol. "And if the court would allow me 5 uninterrupted minutes, I believe I can demonstrate why this case warrants a fundamental reevaluation of how we interpret the First Amendment." Roberts' expression darkened. "Mr. Musk, this court operates according to established procedures. You do not dictate the terms of oral argument." Musk responded smoothly, "I apologize for my phrasing, Mr. Chief Justice. I'm simply requesting the court's patience as I present evidence that directly addresses Justice Sotomayor's excellent question." Justice Amy Coney Barrett spoke for the first time. "I'm interested in hearing this evidence." Chief Justice Roberts glanced at his colleagues, several of whom gave small, almost imperceptible nods. "Very well, Mr. Musk. Proceed." but remain focused on legal arguments. Musk reached beneath the lectern and pulled out a tablet. With the court's permission, I've prepared a demonstration. That's highly irregular, Roberts responded sharply. The court does not typically allow technological demonstrations during oral arguments. Justice Ketanji Brown Jackson leaned forward, interjecting. Chief Justice, given the nature of this case, perhaps we should make an exception. I'm curious to see what Mr. Musk wishes to show us. Robert's frustration was palpable, but after a brief pause, he nodded curtly. Proceed, Mr. Musk. Briefly, Musk activated the tablet, which projected onto the large screen typically used for case materials. What I'm showing the court is a live demonstration of how algorithmic speech functions. This split screen displays identical user profiles interacting with the same content, except one is using one algorithmic framework, and the other is using a different one. For the next 4 minutes, Musk took the justices through a technical yet surprisingly clear explanation of how content moderation algorithms functioned as both technological systems and forms of expression. He demonstrated how government-mandated changes would fundamentally alter the communicative nature of platforms in ways traditional media regulations never could. The government's regulations don't just dictate how we operate, Musk explained. They're telling us what our platforms communicate and how they communicate it. This isn't like regulations on broadcast media or print publications. It's more akin to the government telling a newspaper how to edit its articles or a book publisher how to structure its chapters. Justice Neil Gorsuch leaned forward, his brow furrowing. Mr. Musk, your demonstration certainly sheds light on the technological side, but the legal question remains. Why shouldn't the government have regulatory authority over platforms that have become essential public forums? Musk's lips curled into a small smile, as though anticipating the very question. Justice Gorsuch, that brings me to the heart of my argument. I've prepared a legal analysis that, I believe, answers this question definitively. He produced a document and requested permission to distribute it to the justices. Roberts, growing increasingly frustrated but recognizing his colleague's interest, reluctantly agreed. As the justices reviewed the document, their expressions shifted noticeably. Justice Kagan's eyebrows rose in surprise. Justice Kavanaugh leaned over to whisper something to Justice Thomas, who nodded thoughtfully. Mr. Chief Justice, members of the court, Musk continued, what you're reviewing is a comprehensive analysis of 73 Supreme Court decisions, dating back to 1919. I've identified a consistent pattern in the court's approach to new communication technologies that reveals a clear constitutional principle, Musk continued. When communication methods evolve, the court has consistently extended First Amendment protections before allowing government regulation, not the other way around. Justice Roberts examined the document with visible surprise. Mr. Musk, did you prepare this analysis yourself? I did, Mr. Chief Justice, Musk responded. With assistance from AI tools I developed specifically for legal research, but the analysis and conclusions are entirely my own. Roberts paused, as though reconsidering his words. This is unexpectedly thorough. Musk nodded respectfully. Thank you, Mr. Chief Justice. If I may continue, I believe this historical pattern reveals something crucial about how the court has interpreted the First Amendment through technological transitions, whether from print to radio, from radio to television, or from television to the early internet. In each case, the court extended protections first, and only after those protections were secured did it allow for careful regulation. The atmosphere in the courtroom shifted. What had started as a confrontation was evolving into something more intricate, a reluctant engagement with ideas that, regardless of their origin, clearly merited serious consideration. Justice Roberts set the document down, his expression now more thoughtful than dismissive. Mr. Musk, you've certainly presented a more substantive legal argument than I anticipated. But before he could continue, he was interrupted by Justice Clarence Thomas, who rarely spoke during oral arguments. Mr. Musk, Justice Thomas's deep voice resonated through the courtroom, commanding immediate attention. Your analysis suggests that you've identified a pattern in our jurisprudence that even our clerks haven't fully synthesized in quite this way. I find that remarkable. especially coming from someone without formal legal training. Musk nodded respectfully. Justice Thomas, sometimes an outside perspective allows one to see patterns that may not be as apparent to those within the system. Chief Justice Roberts, whose initial frustration had shifted to something more nuanced, regarded Musk with a reluctant recognition. The man he had initially dismissed now seemed to be presenting an argument worthy of serious consideration. "Mr. Musk," Roberts said, his tone now markedly different, "I believe the court would benefit from hearing the remainder of your argument without further interruption. Please, continue." The atmosphere in the courtroom had undergone a dramatic transformation. What began as a tense confrontation between the Chief Justice and a tech mogul had evolved into a substantial constitutional dialogue with potentially far-reaching implications. For the next 17 minutes, Elon Musk delivered what many legal observers would later describe as one of the most innovative First Amendment arguments in recent history. The tech showman was gone, replaced by a surprisingly methodical constitutional theorist who seamlessly connected historical court precedents with the realities of modern technology. His presentation clearly engaged all 9 justices. "The fundamental question before this court," Musk continued, as he displayed a series of carefully constructed slides to illustrate his legal reasoning, "is whether algorithmic curation of content constitutes protected speech. I submit that, when viewed holistically, the court's own precedents provide a clear answer." Justice Kagan, known for her sharp questioning, leaned forward. "Mr. Musk, your analysis of our precedents is impressively thorough, but there's a crucial distinction you haven't addressed. Traditional media companies make editorial decisions about content they produce or commission. Your platforms, however, primarily organize and amplify content created by others." Musk nodded respectfully. "An excellent point, Justice Kagan," he began, "but I would direct the court's attention to Miami Herald Publishing Company v. Tornillo, where this court held that even decisions about which third-party content to include, in that case, political responses in newspapers, constituted protected editorial judgment." He tapped his tablet, bringing up the relevant passage from the 1974 decision on the courtroom screen. The court wrote that the choice of material to go into a newspaper constitutes the exercise of editorial control and judgment. Our algorithmic decisions are the digital equivalent. We don't merely transmit others' speech. We make millions of editorial judgments about how that speech is organized, contextualized, and presented. Justice Roberts, who had been silently taking notes, looked up. "Mr. Musk, even accepting your analysis of our precedents, there remains the practical question of market power. Your platforms have unprecedented reach and influence. Shouldn't that create different constitutional considerations?" "A fair question, Mr. Chief Justice," Musk replied. He advanced to a new slide that displayed a statistical comparison. "I've analyzed every case where this court has considered market concentration in First Amendment contexts. In 27 decisions over 6 decades, the court has consistently held that the size or influence of a speaker does not diminish its constitutional protections." Musk paused, making eye contact with Roberts. "In fact, Mr. Chief Justice, I would direct the court's attention to your own opinion in Citizens United, where you joined the majority in affirming that the identity or power of a speaker doesn't diminish First Amendment protections." An audible murmur spread through the courtroom. Musk had just used Roberts's own reasoning against him, but with such precision and respect that it came across more as intellectual engagement than confrontation. Justice Barrett spoke up. "Mr. Musk, your legal analysis is surprisingly sophisticated, but there's still the matter of practical application. If we accept your framework, what limits would remain on government regulation of digital platforms?" "An essential question, Justice Barrett," Musk replied, advancing to a slide titled "Constitutional Boundaries for Digital Regulation." "I'm not arguing that platforms should be free from all regulation," Musk began. "Rather, I propose that any regulations must meet 3 specific criteria to be constitutionally permissible." He outlined them clearly. First, they must be content neutral. Second, they must address demonstrable harms, not just theoretical concerns. Third, they must be the least restrictive means of addressing those harms. He shifted to a new slide that illustrated these points with examples. For instance, Regulations requiring transparency about algorithmic decision-making would likely be constitutional under this framework. However, requirements for specific content outcomes would not. Justice Kavanaugh, who had been diligently taking notes, looked up. Mr. Musk, you've presented a nuanced constitutional argument that clearly involved significant legal research and analysis. May I ask why you chose to argue this case personally, rather than relying on experienced Supreme Court advocates? The question momentarily caught Musk off guard, the first sign of vulnerability he had shown. He paused briefly before answering. Justice Kavanaugh, I felt this case required someone who deeply understands both the technological realities and the constitutional principles at stake. While I have great respect for the Supreme Court bar, I felt personally compelled to present these arguments. He glanced briefly at Chief Justice Roberts before continuing. Additionally, I wanted to demonstrate my personal commitment to these principles. This isn't simply a business matter for me. It's about fundamental questions of free expression in the digital age. Roberts, who had been quietly taking notes throughout Musk's presentation, set down his pen. His expression, which had been marked by dismissive frustration earlier, had now transformed completely. He studied Musk for a moment before speaking. Mr. Musk, I owe you an apology, Chief Justice Roberts said, causing a wave of surprised murmurs to ripple through the courtroom. I made assumptions about your legal capabilities based on your lack of formal training. Your presentation today has not only been adequate, but genuinely illuminating. This rare admission from the typically reserved Chief Justice created a profound silence in the room. It was unprecedented. Thank you, Mr. Chief Justice, Musk replied simply, his tone composed. I appreciate your willingness to engage with these arguments on their merits. Roberts nodded, then turned to the Solicitor General, who was representing the government. General Williams, you'll have 30 minutes for rebuttal, but I think you'll agree that Mr. Musk has presented arguments that warrant serious consideration. The Solicitor General stood, clearly recalibrating her approach. Yes, Mr. Chief Justice. If I may, I would like to request a brief recess to review some of the precedents Mr. Musk has highlighted. Granted, Roberts responded. The court will take a 15-minute recess. As the justices rose to leave, several cast lingering glances at Musk, their expressions ranging from surprise to a grudging respect. Justice Thomas, in a rare moment of acknowledgement, actually nodded slightly in Musk's direction. In the gallery, legal reporters were already typing furiously on their phones. What had started as a potential humiliation for a tech billionaire out of his depth had, against all odds, transformed into something entirely different. It was a moment that shattered conventional wisdom about legal expertise in the nation's highest court. The Supreme Court's ruling in Platform Innovation Corporation v. Federal Communications Commission was released 3 months later, on a warm Tuesday morning in June. The 6-3 majority opinion, authored by Chief Justice Roberts himself, sent shockwaves through both legal and tech circles. In determining whether content curation algorithms are protected expression under the First Amendment, Roberts wrote, "We must adapt our constitutional principles to the realities of modern technology without sacrificing their core values." The opinion went on, "We hold that algorithmic curation of third-party content constitutes protected editorial judgment when it reflects expressive choices, rather than purely functional operations. Therefore, government regulations that mandate specific content outcomes or dictate algorithmic designs implicate fundamental First Amendment concerns and must withstand strict scrutiny." Legal commentators quickly recognized the remarkable nature of the decision. The ruling had incorporated several of the analytical frameworks Musk had presented during oral arguments, even mirroring key language used by him. On CNN, legal analyst Jeffrey Toobin was visibly astonished. "What we're seeing here is extraordinary," he remarked. "The Chief Justice has essentially validated Elon Musk's constitutional theory. The court has created a new framework for digital speech that echoes many of the arguments Musk himself presented." The Washington Post Supreme Court correspondent published an in-depth analysis noting that Roberts had cited multiple historical precedents Musk had highlighted, cases that hadn't appeared in the original briefs but had emerged during Musk's presentation. The majority opinion, according to the Post, displayed an unexpected intellectual humility on the part of Chief Justice Roberts. The article observed, Chief Justice Roberts has incorporated innovative legal reasoning from a non-lawyer who managed to uncover patterns in the court's own jurisprudence that had previously gone unnoticed. Within hours of the decision's release, Musk held an impromptu press conference on the steps of the Supreme Court. Gone was the confrontational tech disruptor. In his place stood a measured advocate for constitutional principles. Today's decision isn't about me or my companies, Musk told the gathered reporters. It's about establishing clear First Amendment protections for digital expression before allowing government regulation, following the same pattern the court has consistently applied to every new communication technology throughout American history. When asked about his personal victory over Chief Justice Roberts, who had initially dismissed him, Musk was unexpectedly gracious. Chief Justice Roberts demonstrated exactly what we want from our judiciary: a willingness to engage with arguments based on their merits, no matter their source. His intellectual integrity in considering these ideas, despite his initial skepticism, reflects the best traditions of the court. The impact of the case extended well beyond the legal questions at hand. Law schools across the country quickly included the case in their constitutional law syllabi. Harvard Law School even introduced a new course on technological innovation and constitutional interpretation, with Musk invited as a guest lecturer for its inaugural session. Perhaps most surprisingly, Chief Justice Roberts himself addressed the case during a judicial conference the following month. In remarks that went viral, he spoke with unusual candor. In my 17 years on the court, I've learned that wisdom can come from unexpected sources, Roberts told the assembled judges. The platform innovation case reminded me that our legal system benefits when we remain open to novel perspectives, especially when they challenge our assumptions about expertise and authority. He added, with a rare touch of humor, it seems that disruption can occasionally be a positive force, even in institutions as tradition-bound as the Supreme Court. The relationship between Roberts and Musk evolved in ways no one could have predicted. 6 months after the decision, they appeared together at a Stanford Law School symposium on technology and constitutional rights. Their discussion, Roberts advocating for judicial caution and Musk for technological innovation, revealed a remarkable intellectual rapport that had emerged from their courtroom confrontation. What I've come to appreciate about Mr. Musk's approach, Roberts told the audience, is that he tackles legal questions with respect for precedent while also being willing to reconsider first principles. That balance is something every jurist aspires to achieve. Musk, for his part, expressed newfound respect for legal institutions. Working through these constitutional questions has given me profound respect for the careful way the court balances competing values, he said. There's a wisdom in that methodical approach that technologists would do well to understand. The case not only transformed First Amendment jurisprudence but also reshaped the relationship between the technology sector and legal institutions. Tech companies began hiring constitutional scholars alongside engineers, recognizing that their work was increasingly entangled with fundamental rights and legal principles. Law firms responded by establishing specialized practices that combined technological expertise with constitutional advocacy, bridging the gap between Silicon Valley and Washington. Several technology executives, following Musk's example, pursued legal training, realizing that the future would require leaders who understood both code and constitutional principles. For ordinary Americans, the case symbolized something even more fundamental, a reminder that in a constitutional democracy, even the most powerful institutions remain accountable to reasoned argument. The image of the world's wealthiest individual successfully advocating before the nation's highest court, not through power, money, or influence, but through meticulous legal reasoning, provided a compelling civics lesson on the American system at its finest. A year after the ruling, a documentary titled The Unlikely Advocate, Musk, Roberts, and the Future of Digital Rights premiered at the Sundance Film Festival. The film featured interviews with legal scholars, tech experts, and even some of the justices themselves, examining how the unexpected courtroom confrontation had reshaped the constitutional understanding in the digital age. In one of the film's most poignant moments, Chief Justice Roberts reflected on the case's impact on his understanding of expertise and preconceptions. "I've spent my career in legal institutions," he said, "surrounded by people with similar training and backgrounds. What Mr. Musk showed us is that sometimes it takes an outsider to help us see our own principles in a new light." The film concluded with a striking split-screen image. On one side, Chief Justice Roberts in his judicial robes, embodying the enduring institutions of American law. On the other, Musk, the visionary tech leader who had reshaped the legal landscape through intellectual engagement rather than traditional influence. The juxtaposition underscored the lasting significance of the case, symbolizing how open-mindedness and a willingness to reconsider long-held views could lead to profound change. The image of the world's wealthiest individual successfully advocating before the nation's highest court, not through power, money, or influence, but through meticulous legal reasoning, provided a compelling civics lesson on the American system at its finest. A year after the ruling, a documentary titled The Unlikely Advocate, Musk, Roberts, and the Future of Digital Rights premiered at the Sundance Film Festival. The film featured interviews with legal scholars, tech experts, and even some of the justices themselves, examining how the unexpected courtroom confrontation had reshaped the constitutional understanding in the digital age. In one of the film's most poignant moments, Chief Justice Roberts reflected on the case's impact on his understanding of expertise and preconceptions. "I've spent my career in legal institutions," he said, "surrounded by people with similar training and backgrounds. What Mr. Musk showed us is that sometimes it takes an outsider to help us see our own principles in a new light." On the other side, Elon Musk, dressed in his signature casual attire, represented the spirit of technological disruption. Between them appeared a quote from Justice Louis Brandeis, penned nearly a century ago, yet strikingly pertinent in the modern digital era. "If there be time to expose through discussion the falsehoods and fallacies to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence." The case involving Chief Justice Roberts and Elon Musk highlighted an essential truth. Even amid rapid technological change, the core principles of the Constitution remain not as rigid constraints, but as living ideals, capable of evolving to meet challenges that the framers could never have foreseen. Thank you for following this remarkable journey of legal confrontation and unexpected brilliance. Don't forget to like and subscribe for more in-depth analyses of the landmark Supreme Court cases that are shaping our constitutional rights. Share your thoughts in the comments. Do you believe non-lawyers should be allowed to argue before the Supreme Court? We'll see you in the next video.